Hello there, warm welcome to this video presentation. Today we are going to talk about the ASIC versus Citigroup 2007 case. For discussing this case, me, Diwas Chaulagain, will be with you, including my colleague Saraswati Wagle, Lakshmi Acharya, Sujana Thapa. The purpose of this presentation is to outline the duties or responsibilities of director, breach of duty if any, discussing and analyzing the court decision and reason behind the decision based on the Corporation Act. The report studies the case of the Australian Securities and Investment Commission, that is ASIC versus Citigroup 2007. Citigroup is the Australian arm of the mother company called Citigroup Inc., which includes the financial services such as investment banking and equities trading. The company had established a firewall called Chinese Wall to restrict and prevent the interflow of the critical information between the various departments. The dispute arose when the proprietary trader of the group purchased a share in the Patrick Corporation Limited while investment decision of the company was acting as the representative for the Toll Holding Limited, who was the client at that time. ASIC condemned the act of Citi acting as an advisor and purchasing share which breached the duty of loyalty according to section 912A1AA, and this activity gave rise to the scenario of conflict of interest.
Hello everyone, my name is Saraswati Wagle. Today we are discussing about the case ASIC versus Citigroup, and my friend Diwas has already mentioned about the introduction part of the case. Now I'm going to talk about the director's duty and then responsibilities. Talking about the director's duty, there are four main duties of there, and then I'm going to talk about in little bit of details. The Corporation Act 2001 specifies four main duties of the directors. One is care and diligence. To act with the degree of care and diligence that a responsible person might be expected to show in the role. It's section 180. And next one is good faith. To act in good faith in the best interest of the company and then for a proper purpose is under section 181, including to avoid conflict of the interest and to reveal and manage conflict if they arise under section 181. Of the Corporation Act, directors and other officers must exercise their powers in good faith in the best interest of the company and for the purpose. And third one is proper use of position. To not improperly use their position to gain an advantage for themselves or someone else or to detriment to the company. And fourth one is proper use of information. To not improperly use the information they gain in the course of their duties, traders' duties to gain an advantage for themselves and someone else to the detriment to the company is under section 183.
Hello, I'm Lakshmi Acharya. As we are discussing about the case ASIC versus Citigroup 2007, I will be outlining why the duties were breached in the case. ASIC had claimed that Citigroup had breached the following basis. The remarks included the cleverly worded exclusion clauses on the contract papers, which transformed the relation in less demanding. Citigroup breached the insider trading provisions contained in the section 1043A of the Act because equity trading had assumed that Citigroup was acting for the toll to make takeover of Patrick, but ASIC supports the constituted information within the meaning of that term in section 1042A of the Act without having any real evidence of the sale of 200,000 shares to have the constituted insider trading by Citigroup. ASIC contends that Citigroup, as an advisor to Toll, occupied a relationship that was in critical respects fiduciary. ASIC claimed in the alternative that Citigroup breached the provision of ES 1043 of the Corporation Act and ES 12DA of the ASIC Act, which prohibit the misleading and deceptive conduct. ASIC also makes two claims against Citigroup of the contravention of the insider trading provisions contained in ES 1043A of the Corporations Act. The first claim covered the trader's sale of Patrick shares late in the afternoon after he was given instructions not to buy those shares. The second insider trading claims covers all of the trading undertaken by the trader on the day in question. ASIC alleges that senior officers of the corporate investment banking division of Citigroup knew that there was a substantial likelihood that toll would launch its takeover bid on the next working day after the shares were purchased.
Hello, this is once again Diwas. I will be discussing in more detail about the court decision and the course itself. The issue has emerged when the public side working with the Patrick Corporation Limited share were on the bid. The toll holding, which was a client of the Citigroup as a private employee, was about to trade. The Citigroup owned the share through the proprietary trading the day before the toll announced a bid for the share. The decision was considered much important that the Citigroup involved of the international investment. The issue had given right to the clash between the international investment banking community and the Australian financial regulators. The Australian Security Exchange Limited has doubted that the insider trading between the Patrick and the Citigroup has requested the ASIC for the further investigation. The ASIC has grabbed up the claim based on the 192A1AA of the Corporation Act based on the adequate arrangement for the conflict of interest by the management. But His Honor Jackson refused to claim conducting that the party are open to contract to modify or exclude the fiduciary duties operation.
Hello, I'm Susna Thapa. I would be critically analyzing the reason behind the court decision on ASIC versus Citigroup 2007. According to the ASIC 2007, the Federal Court of Australia come with the decisions with the key findings such as Citigroup did not engage in insider trading and it doesn't breach the provision for conflict of interest. While making the decisions, His Honor had took the case on different allegations. The first allegations is insider trading. ASIC tried to build a case upon the allegations made against the Citigroup that the company had passed the price sensitive and the critical informations, which result in an insider trading. The court did not agree with the finding made by the ASIC as the amount of information needed to be convinced trading was not relevant as was suspect by the ASIC. It was clarified by the federal court with an suitable example of operations of the Chinese wall and interflow of sensitive information. The second allegation is conflict of interest. The second field of interest for ASIC was the breach of fiduciary duties and the presence of conflict of interest. ASIC alleged Citigroup that they have contravened Section 91A of the Corporations Act 2001, but the court did not agree to these allegations as the contract clearly mentioned about there was no fiduciary duty imposed on Citigroup at the time of transactions, and if it so a duty were imposed, there was a sufficient information consist prior to the insider trading. Hence, Citigroup had not breached their fiduciary duties under Section 91A of Cooperation Act. Finally, I would like to discuss about the third allegations with the Chinese wall. While examining the full proving of Chinese wall of this group, the court held that there was no clear requirement by the Act for defense system to be broomed with perfections. Rather, it merely had to fulfill the basic step needed. Thank you so much.
To sum up, His Honor has gone to different alignment made by the ASIC to the Citigroup, and His Honor has dismissed the case, and the ASIC has to pay the Citigroup precedent cost. The case has gone through the similar case analysis on the consultation paper published by United Kingdom Law Commission 1994. The remarks include the cleverly worded exclusion clauses on the contract paper, which transform the relation in less demanding. The Jackson President has concluded that the agreement between the toll and the Citigroup was silent regarding the fiduciary relationship between the parties, although it was found that ASIC has claimed that toll had shown express intention for the fiduciary duties, but the court denied such claim. Upon considering all these situations, his owner concluded that there was no any insider trading and no situation of conflict of interest as of Corporation Act. Thank you for watching this video. Please provide us feedback on the comment. Thank you.